that was happy to be here for you. So please do that. So I wanted to introduce Jim Lacey. So now I have a business guy, and this guy, he's a businessman. We're a businessman. After graduating from college outside of Pennsylvania, he was a CPA. He worked for Recorden in Pittsburgh. He founded his own CPA firm in 1989. He served as a volunteer firefighter, later became the mayor of the mayor of the Lodge. Jim grew up in a blue-collar family. He was the first in his family to graduate from college. He moved to Ohio 34 years ago. He's been married to his wife Tina for 34 years. Last October, he's blessed to have 3 children. And basically, he's got kind of a remarkable story. He owned a Chevrolet dealership in 2009. Does anybody remember what happened in 2009? The federal government took over General Motors. He had a General Motors dealership up north, and one day he got a letter and said that they were going to not allow him to continue to use the government. And based on that, Jim decided to run for Congress in 2010. He's in his third and a half term there, and he made a decision he wanted to career Ohio. He wanted to become federal governor. And I just think it's great that you have an opportunity to meet people running for governor. And I'd like to welcome our guest, Jim Lacey.
All right, well, thank you. And I gave a first hint at who I am. As you heard, being in Ohio 34 years ago, always believed in giving back. Started my first business at age 24. Had a couple $100 in the bank account. My parents taught me early on, work hard to do the right things. Anything's possible in this great country, especially this great state. Western Pennsylvania, when we graduated from high school, we ended up being one of the coal mines of the steel mills. I always believed Ohio was a place that had an opportunity. I came here. I came here, started that first business, grew to 60 businesses, created over 1,500 jobs, employed over 3,000 people. When I did that, I never really thought about politics, but I always thought about getting back. My parents used to always teach me, when you climb up the ladder, bring people with you. The other thing my parents always taught me is anything's possible as long as you work hard to do the right thing. And I did that. So I was able to live the American dream here in Ohio. I went from a very poor kid from Western Pennsylvania to now somebody who has everything. During those years, I also was a big believer in giving back, and I still am a big believer in giving back in community service. I was on the fire department for a number of years. I was a volunteer at the fire department EMS. I was on the planning commission for zoning appeals. I didn't have a short stint as mayor. People said to me, a business community came to me, I was running multiple businesses. They said, what a great person. We had a city, Boston, Ohio, that was running about an $8 million budget, losing about $1.5 million a year. Did not know how to fix that city. They did not fix it. They asked me as a businessman, I said, here's what I'll do. I'll come in, I'll turn it around, and I'm going to leave. That's what I was able to do. After 7 years, I was able to create a change from a deficit to a surplus without paying tax. By the way, it can be done. So how did I go to college? How did I go to Congress? Why did I go to Congress? And one of my businesses was the Chevy dealership. I had multiple businesses. One was the Chevy dealership. I got to tell you, you heard me say, I got this letter. After General Motors came to me and asked me to help turn around that business, and I did. I got a letter that said, well, I'm no longer part of the Chevy family. I told them to come down and dinner to me. I was like, getting kicked in the stomach. Anytime the federal government come out, take something from you as a citizen, take it away from you. That's when government has gotten too powerful and too strong. What did I do? Because I wasn't sure what to do. I was concerned about my 53 employees. I called my U.S. Congress. I called them and I said, look, I understand members of Congress can help their constituents get the dealership back. This member of Congress, of course, gave money. So, yeah, I can help you. I can do that. Came and visited me. I believe in businesses. I believe in car dealerships. I believe that that's, the great part of the community to have these small businesses. I'm going to help you. The problem was he was a member of Congress. And that's what I didn't realize. Sometimes they say things, that they don't, they say one thing, but they don't do something different. When the vote came back for me to have my dealership reinstated in July of 2009, Congress voted against it. So I called him up, and I said, not only are you a liar, you're somebody I can't trust, I'm going to remove you from that office, you're not to jump in. 30 days later, I jumped into the race, because I was so mad at Washington, and 14 months later, I became a U.S. Congressman in the 16th District of Ohio. I have now been there 6.5 years. I will tell you, Washington is broken. If you're about it, you're frustrated with it, you should be frustrated with it, I am too. And people say, I just don't like that Congress. I don't like what's going on in the State House. But by the way, we have the same problems in the state of Ohio, I'm telling you about. But if you want to fix Washington, you want to fix the state, I always tell people when I'm talking to them, go up in there and look in that mirror, because that's the problem. Because we keep voting the same people. If we keep voting the same people, we can get the same results. If you're mad at Washington, why do you vote the same person in? Well, I like him. Or he or she's been good to me, or they shake my hand, they come to see me. Same thing in the state government. What I really believe now, after being in Washington for 6.5 years, there's only one way to fix Washington. I want to come back, I want to go. This is what I believe. Because many years ago, our founders said, we give Washington $1,000,000, we give our federal government $1,000,000. Now they have extraordinary powers. They can take businesses away from you, just like they took from me. As a governor, I want to be the type of governor who teams up with 39 other governors and says, enough's enough. We're going to take back that power that you have. We're going to push you on two things. I believe fixes Washington. Here's what they are. Number one, we force them to balance the budget. Number two, we do something. Now, 6 years ago, I would have never told you that, but I now believe in determining this. The only way to do that is at the state. Now, let's talk about the state, because I think that's important as well. If somebody says, well, so you're going to come back, you're going to run for governor, and you're going to do that. Absolutely. That's the type of governor I'm going to be. Let me tell you what we have in the state. Switch to the state, because you're unhappy with Washington, you should be unhappy with the state of Ohio. Today, our state, this is 2011, is marking 21st to 37th in job growth. 21st to 37th. We're number one in Medicaid dependency. Number one state in the country in Medicaid dependency. 1 out of 4 people in this state are on Medicaid. We're number one in opioid overdose and addiction. Number one in opioid overdose and addiction. We're number one in college debt. People know us. Number one in college debt. Our state budget is balanced by using 50% federal dollars. None of you should accept that. Think about it. The federal government is borrowing 35% from China, and they're given to the state government, and the state government balances its budget with 50% of federal dollars. Unacceptable. None of this is acceptable. I came here 34 years ago because I believed Ohio was the land of opportunity, and it was. 34 years later, I'm not sure it is the land of opportunity anymore. In fact, we're the 8th most left state in the country. Not left politically. Left, we got the car, got the bus, got the train, got the plane, and left. Our people are leaving. Why are they leaving? Because we're not giving them the opportunities that they deserve. We're not giving our children and grandchildren the opportunities that they deserve. Just a couple of quick things that we need to do in Ohio. Number one, right today, we believe in Ohio that everybody should get a college education. We reward our high schools, K through 12, on getting people to college. I was in a high school the other day, 1,300 students. I asked the superintendent, how many kids are going to go tech? He said, 29. He said, yeah, we are preparing our kids for the future. I said, you're preparing our kids for disaster. 1,271 kids should not be preparing for college. You can have a good, you can actually have a good career and a good opportunity for a good future and not go to college. I have a friend who's a plumber, got a plumbing certificate, got his, started his own company, he just sold his company, now lives in Florida with a big house and a big boat, and never went to college. You don't have to go to college. And yet, we drive our kids to college. That also drives them to college. If you're not, I don't know if you're in addiction group that I brought into my office somewhere or listen to I want to change our high school education now, so it's starting in 6th grade. see other opportunities. Not our college, tell me about other opportunities. What I learned was there's a goal now, 3 o'clock in the afternoon, the baseball, kids want to go, frustrated, they don't want to go, they're out of the night, hang around with friends, you struggle through it. Another problem. You want to go through that issue? Let's do a couple things. Let's give our children an opportunity to start in 6th grade. Let's reward our high schools. Not our test set or skill set.
I'm not sure what we're going to feedback.
Graduate our kids not only with a skill set, but free. This is another big issue. So education funding, Medicaid expansion. I'm going to eliminate the Medicaid expansion. Unsustainable. Medicaid is unsustainable, causing us problems. And when you're one person say, what are we going to do about Medicaid expansion? Here's my answer. 19 other states don't have Medicaid expansion. A lot better. Medicaid expansion is on. By the way, you have these sanctuary cities. Promise you, government moves up. This stuff is pretty simple. I tell you, here's how we fix it. Whether it's sanctuary cities, whether it's oh wait, you hear about here's the difference between the one that's on front of it, not the one that's on the back of it, not the one that's back of it. If you're back at money, everything, people the house, fire, what more do you want to give them? You give them everything.
Try hand it in the other hand.
In the last 8 years, we have gone, I think, the 94th state is environment. I can blame myself as one. I don't do these guys well. Never done any raise. Now I'm having in Washington, cannot support a job from for the primary round. Before I did that, that would be suicide. I'm so glad for a politician not supporting Donald Trump, didn't support Donald Trump, as Vice President of the fly in, me, while supporting me. We work together, unchanging, but like the proposal, like somebody. Also, I'm on top of higher. Thank you. This is the city. Debate Monday night.
John versus since we were given the first two questions that were asked that night. The rest of the line first question we asked is about their sanctuary city. So make sure you tune online for that, or hopefully you can join us. I'm going to introduce Betty Overstreet, who's our community development director, who's going to introduce our guests. Let's give Betty a round of applause.
Thank you, Dan. Before I introduce everyone, when our speakers finish, we will have a question and answer. If you want to ask a question, please raise your hand and we press the microphone to you so that everyone can see you as well as online.
It's still choppy.
Sean Maloney is a defense attorney and member of the National Association of Criminal Defense Lawyers, who practices in all areas of firearm-related law, including Second Amendment rights, criminal defense, federal and state restoration of gun rights, and federal anti-success. He has appeared as an expert witness in a variety of civil lawsuits related to firearms. As a leader of the Firearms Association,
Send a message.
Send
a message. Send them a chat. Just have to work.
Sean Maloney serves as legal counsel for the Firearms Association.
We go.
Time for arranging some things. My cheat sheets are just a little bit too big. That's it on that. I want to thank everybody for having me here this evening. First, before we get started, there's some important things to do. I have every first responder, every police officer, every member of the military of any kind who's stand up. Don't be bashful. Thank you. And then I give this book away. Go through everything. And usually I don't pimp other people's stuff, but this was such a great book. And I met Laura in 2013 when Mayor Bloomberg in New York City decided to go to Colorado and throw his millions of dollars around, and it was successfully passed some of the most stringent anti-gun laws that there were. She got sick and tired of it with another friend of mine, Tim Knight, and they successfully recalled 3 state senators for the first time in 80 years. Put a petition, you signed petitions, you put them on the ballot to vote them out of office. They successfully did that, and the first person did that too was the president of the Senate in Colorado. And that's when I met her. She's a huge Second Amendment advocate, and she wrote this book, The Government Ruins Nearly Everything. And it talks about key issues, and as an attorney, I said, well, we need a law that does this. We need the government to do this. Well, no, we don't. We need to give the government permission to go to the State House or go to Washington, D.C. and do nothing and repeal these bills. And it's a great book. It's introspective, and it'll get you thinking. There are $10. There's a few left in the back, and I can get more, but I mean, it changed the way I thought about a lot of things. And when you meet Laura Carno through this book, she's an amazing speaker, and she's brought Faster to Colorado when we talk about Faster also. I have to start out with disclaimers because I'm an attorney. Anything I say tonight doesn't create an attorney-client relationship between you and I. Just talk to me afterwards and we'll take care of that. If you need specific legal advice with anything, seek an attorney, whatever state you're on, online. Most of this is going to be Ohio-based, but some of these principles I'm going to be talking about really are universal principles, and it's lethal force and law. The laws on lethal force are pretty similar throughout the United States, but when you get into concealed carry and things like that, the laws are different. And when I talk about lethal force in the law, I'm also an NRA instructor. I've taught thousands of people basic pistol, rifle, and shotgun. I've taught concealed carry for thousands upon thousands of people. And I realize at times that I'm afraid that they take my class and then they put their gun in a nightstand. And they don't pay attention to what's going on. They never really practice again, or they never think about the law, or they read the Attorney General Handbook from Ohio and kind of got a little bit of the law, but didn't get a whole lot. And so for those people, I started creating seminars. And lethal force in the law is I think one of the most important seminars, because it tells us, it draws a line in the sand, so to speak, when we can legally use lethal force to protect our lives or the lives of the people we love, period. Because there's so many people that think, well, when can you use lethal force? Well, I'll know it when it happens. Really? Well, you see, we're the good guys with the guns and good girls with the guns. And one thing that we're going to do is we're going to wait too long, because we're the good person. And this teaches you when you can actually pull that trigger, if that's what you need to do, and defend yourself. And I did that because too many people were waiting too long. And if you're a concealed carry holder, pat yourself on the back, because you're the safest, most law-abiding segment of society. Now that they have records on us, you have the FBI uniform crime reports and the CDC reports prove once and for all that we're the safest, most law-abiding segment of society. So congratulations and thanks for doing that for all of us. Now, what is lethal force? Lethal force is that force necessary or likely to cause death or serious bodily injury or harm. What does it's subjective. What does the victim or what does the defendant think? What do you think? And the reason why I say victim defendant, you have to understand the laws of the United States. If I'm sound asleep in my house, someone kicks my front door open, and I have to defend myself and my family, the minute I do that, guess what I am? I'm the defendant. The person that's laying on the foyer or inside the threshold or no matter what, that's the victim. That's the way we start out with the laws in America. And that was important. And as a criminal defense attorney teaching a concealed carry class one day, I was standing up and reading the Ohio Attorney General Handbook and said, the defendant, and I said, wait a minute, I'm not the defendant, but yes, we are. So that's another reason why I have this. I don't have to know for certainty or with certainty that someone's crashing a baseball bat against my forearm or my skull is going to cause serious bodily injury or death, but it's likely, and that's enough. The phrase defining lethal force is found in nearly every state statute if such person is not at fault for creating it. So, and this is the way we have to start. You can't create the problem. You can't start the fight and then use deadly force or self-defense to defend yourself. Once you start it, unless you retreat and say, okay, I don't want any more part of this, I'm done, then your ability to use self-defense or self-defense begins again. So if the person is not at fault, and such person reasonably and honestly believes that he's in immediate fear of death or serious bodily injury or harm, and really think about the only means for our escape is to use deadly force. That's when you can legally use lethal force. And we'll get into stand your ground and to do the retreat states. Talk about the duty to retreat. Duty to retreat in its most extreme form states that a person who is under an imminent fear of death or serious bodily injury or harm must first retreat as far as they possibly can before they use lethal force. State of Ohio, we have a duty to retreat. Now, we also have the castle doctrine, and there's no duty to retreat when we're protected by the castle doctrine in our homes or a house we have a legal right to be in, or our car or a car of immediate relative. We don't have a duty to retreat then, but everywhere else we do. Think about this, and if you remember that the only means of escape from danger is by using lethal force, that's a pretty good definition. And then in a stand your ground state, it's not a dirty, hairy law. It's not a license to kill. When you're in a stand your ground state, all that says is that it revokes the duty to retreat. You have no duty to retreat. The standard is exactly the same. Once subjectively, I can say I was in fear of death or serious bodily injury or harm, then I can use lethal force. Same standard for stand your ground state. I have to be in fear of death or serious bodily injury or harm before I can do anything. Duty to retreat state, I have to be in fear of death or serious bodily injury or harm before I can do anything. But in a duty to retreat state, I have to think, well, how far can I retreat before I use that? Is everybody clear on that? was a lot of confusion because, of course, the media, in the mainstream media, every time something would happen, all of a sudden, stand your ground, it's dirty, hairy law, it's a license to kill. Who remembers the George Zimmerman trial? Stand your ground wasn't even part of that trial. It didn't have any bearing, but as soon as George Zimmerman was acquitted, every progressive in the world, the media latched onto it. We have to revoke stand your ground throughout the United States. I'm just going over some general principles before we get into things deep. So remember, when you're considering the duty to retreat, when you're considering whether you can use lethal force, or whether you're considering stand your ground, it's always the same bright line. Am I in fear of immediate death or serious bodily injury or harm? In the state of Ohio, just add a word. Am I in fear of death or am I in fear of unavoidable death or serious bodily injury or harm? Because we have a duty to treat, and if it's unavoidable, then that takes care of that standard. Remember, the only means of escape is for you to use deadly force. Now, if you travel and you carry your firearm or concealed carry from Kentucky or Indiana and you're here, you got to make sure you know the laws of the states that you're in. There's a lot of different ways to do that now. With the internet, it's all over the place. Handgunlaw.us is one of my favorite ones, and it became one of my favorite ones because a lot of the police departments use that system because they're pretty up to date on the laws of different states. So, like for example, in Arizona, if you happen upon somebody committing an arson in a habited dwelling, you can use lethal force, no question. Stop rapes, stop child molestation. So the laws are different throughout the United States, and you need to make sure that you're aware of what they are. Now I'm going to say it again. I was in fear of immediate death or serious bodily injury or harm. You need to memorize it. You need to practice saying it, because I guarantee you, if you're forced to use your firearm in self-defense, nobody in here, and I mean nobody, will have any idea what is going to come out of your mouth, just because of the psychological and physical aspects of a threatening encounter and what happens to your body, and I'll get into that a little bit. But you've got to practice saying, honey, what do you want for dinner? I was in fear of death or serious bodily injury or harm. What? So you get my point, because when it's time to say that, the only reason why any law-abiding citizen or any of us good folks in this room use lethal force is because we are in fear of death or serious bodily injury or harm, period. That's the only reason why we do it. I was using the example of a gentleman in Pennsylvania called Big Montana. Big Montana and his wife went up to the front porch of their house and were unlocking a door after coming home from a movie. They were both attacked. Big Montana just had open heart surgery, was knocked to the ground, was being pummeled, beaten, and kicked, and he's thinking, oh my God, I have all this blood thinner, I'm going to bleed to death. He was armed, he pulled his firearm, and he shot his assailant. Now, as any good guy and any girl with a gun is going to happen, he collapsed to the ground, got shot in the femur. Wife was on the phone with 911 applying direct pressure to save his life, the guy that just tried to kill him. So Big Montana goes to his pickup truck to put the firearm away because he didn't want to be standing with the gun in his hand when the police rolled up. And so his wife's on a 911 call, and everything's being recorded. When you think you're on hold in a 911 call, you're being recorded. So he's being recorded, and all of a sudden, he starts screaming, you SOB, I hope you bleed to death. You're bleeding like a stuck pig. I should have shot you again. All this stuff is coming out of his mouth because of the psychological aspects of a threatening encounter, making uncontrollable statements. Well, the police investigated it. Everything was fine until 2 or 3 days later, the prosecutor got a copy of the tape. And here's this tape, and even though the evidence shows he's being attacked on his porch, well, why was he saying these things? So Big Montana was indicted for manslaughter. And I got involved in the case 2 to 3 years later, as it was languishing on. Dick Heller from Heller versus Washington, D.C. gave me a call and said, hey, I got a call. You may want to talk to this gentleman. So I got involved, and within a few months, actually, it was all over with. But that's why it's important that we don't say anything, and we practice saying I was in fear of death or serious bodily injury or harm, and make the 911 call, summon help. That's the purpose of the 911 call. The only purpose of the 911 call is to summon help, not to argue your case on the line. You're being recorded, and that's our first contact with the police. I'm not saying you to be facetious. I don't want you to lie. I don't want you to be elusive. But you do not have the ability, after you've used the firearm of self-defense, to even remotely tell the truth because you don't know what's happening. You've had rush of adrenaline, norepinephrine is streaming through your system, which is increasing your heart rate. Your capillaries are getting smaller. The blood is being shut off your extremities. You've had tunnel vision. The only person you see is a person attacking you. Hearing deprivation. You don't even know what's going on. You can't tell how many times you fired the gun. You've lost time and space. You have no idea what's going on. Your brain, sometimes it takes 60 to 90 minutes for your body to physically return to the pre-arousal levels at the adrenaline leave. Sometimes it takes 6 to 9 years, or you never get the memory of what happened back. That's why when you make a 911 call and they want to start asking you questions, you can't answer the questions because you won't be telling the truth because you can't. So I always instruct people, when you make a 911 call, if it was me, my name is Sean Maloney. I live at 4793 Willow Ridge Court. I was in fear for my life. There's been a shooting, sending ambulance and police. I'm 6'2", I'm bald, I'll be in boxer shorts and a white t-shirt in my driveway. And I hang up. Because I have nothing else to say. I've summoned help, I've done whatever I need to do. Everything else, especially if it's still an active crime scene, you don't want to be disturbed or you don't want to be on the phone. But that's all we need to say. We don't have a duty to say anything else because we have no idea what we're going to say. I hope he bleeds to death. I should have shot him again. Has anybody ever experienced, whether in falling out of a tree? I use falling out of a tree as an example because I fell out of a tree and everything turned to slow motion. Hearing deprivation, everything echoed. I could hardly hear things. I was in a car accident and everything went into slow motion. It seemed like the car accident took 5 minutes to get over with. Those are the psychological aspects of a threatening encounter. Any of our military heroes in here, if you've been in a combat situation, you've all experienced it. We've all experienced to some aspect. If we've been in an argument with a brother or sister, even as a kid, and we're shaking when it's over with, that's the adrenaline leaving our system. When you look at critical decision-making processes, when the stress goes up, our ability to think goes down. That's why for all the well-armed women in here, for all the concealed carry holders in here who practice on a regular basis, that's why you have to practice, because you can't stop the adrenaline, you can't stop the norepinephrine, you can't stop the tunnel vision, but you can train so you can get through it. And that's why training is so important. Your muscles are getting stronger. Just any huge number of things happen. Anybody on beta blockers in here for high blood pressure? I was until I took myself out. Beta blockers dampen down your sympathetic nervous system. All those things we talk about, your strength, the adrenaline, everything it takes to be a lean, mean fighting machine, so to speak. Beta blockers dampen that part of the nervous system, so we're not reacting to anything. It's almost like we don't care. So I always tell people, talk to your doctor, and a lot of times they're not aware that the beta blockers do affect the nervous system, and that's an important thing to know. And actually, I was talking to, I think I was in a seminar with EmpowerU, and he said that. He said, you don't want the guy standing next to you who's got your back to be taking beta blockers. And so I looked into that. That was just something you may want to talk to your doctors about. Now, you've just experienced the psychological and physical reactions of a threatening encounter. 911 can help you. Tell me what happened right now. And then the game is on, because you have no idea what's happening. You're trying to think through it. Your brain is trying to sort that out. And eventually, they will sort out 2, 3, 4, 5 weeks, 4 or 5 days. There's not a police officer in the world that's expecting to make a statement right after they're involved in a shooting, because they understand and that you can't make good comments at that point in time, that you don't know exactly what happened. We're not trying to make up lies, but our brains just simply don't know. Like I said, it takes 60 to 90 minutes for the body to return physically, but a lot of times you may never come back. Your life is going to be changed by what happened. Now, who's heard of the reasonable person doctrine, or the reasonable man? Why is the reasonable man or the reasonable person important? I always say the reasonable man or the reasonable person is important because that fictitious person, those are the standards that you're going to be tried by. When you have 12 people in a jury box, they're going to be instructed what a reasonable person acting under the same facts and similarities done the same thing. So you're using the morals and customs of the community. So if we were a town, everybody in this room, we would take a poll and find out what are the customs, what's reasonable for us to do, how do we feel about everything, and what we came up with, that would be the reasonable person for this town in here right now. Well, what happens when you're in a jury box is it's full of those reasonable persons. Well, granted, I have no problem, being tried using the standards of a reasonable person. What would a reasonable person acting under the same facts and circumstances have done during the situation? Except for the fact, I just got back from California at about 4:48 this afternoon. I had been in San Diego. I had been disarmed for the first time since I was probably 18 years old, where I didn't travel. I didn't know what to do because of the firearms laws and everywhere I was going to go, so I chose not to carry. But I say that because I promise you that the reasonable person in this room here tonight is not the reasonable person from San Diego, from San Francisco, from Los Angeles. Is not the reasonable person from Cleveland, Ohio. Is not even a reasonable person from Columbus, Ohio. Things change. That standard changes. And we've got to remember it's a subjective standard. So how then, if we're traveling, I grew up in Corey, Pennsylvania, near Lake Erie, and had to drive through Cleveland for years and years and years to see mom and dad bring the kids home. But they just don't think like us. They're very anti-gun, they're very progressive, and mentioning a firearm in that part of the state is like mentioning a bomb in an airplane. And so what happens if you're forced to use self-defense in Cleveland, Ohio, or San Francisco, or San Diego, or New York City? How do we become the reasonable person? We do it with local counsel. That's why it's important, and part of the reason why I started Second Call Defense was I realized early on that I'm most effective within a 40-mile radius of where I practice. I know all the judges, I know the prosecutors on a first-name basis. They know me, I know what they're thinking. And all of a sudden, if I go and I'm in Columbus and I'm on my own, I'm going to get homered. I'm not from there. I don't know, this judge doesn't like me to wear a blue tie or whatever is that day. And so it's very important that if you're forced to use a firearm in self-defense, that you get the best legal counsel available wherever the shooting took place. And if you go to secondcalldefense.org, you'll read more about that. There's a lot of white papers on there, how to handle the 911 call. There's a great downloadable book on lethal force and law for you to read. But it's important that we be able to step in the shoes of a reasonable person. Because generally speaking, a jury is the fact finder. You don't care, who's telling the truth and who's not. You find the facts. You're really not, especially in a civil trial, you're not supposed to step in a person's shoes. But if it's a self-defense shooting or it's a self-defense anything, the jury instructions are going to include instructions that encourage you to step in the shoes of that person and decided what would a reasonable person acting under the same facts and circumstances have done, and then to make the decision. Like I said, local counsel is so important. Now, why do we use lethal force? The only reason. You can all say it at once: because they're in fear of death or serious bodily injury or harm. That's why we use it. Now, how do we convince that reasonable person, or those 12 reasonable persons, or that one reasonable person, if it's a bench trial, that we acted properly, that we reasonably use self-defense? I look at the acronym, the administration of justice: ability, opportunity, and jeopardy. The person that I shot because I was in fear of death or serious bodily injury or harm had the ability. I'm standing over top of me with a knife. All he has to do is bring his hand down. Certainly the ability is there, and you can think about the ability of any number of ways. The opportunity, he's right here. All it has to do is bring his hand down, the opportunities, and then jeopardy, you're in fear for your life. You're in jeopardy. So once we've established that we are in fear of death or serious bodily injury or harm, well, how do I show that to the reasonable person? Because that person had the ability, had the opportunity, and had the jeopardy. Now, if they're on the other side of Northern Boulevard with a knife screaming, when I get over there, I'm going to kill you, certainly they have the ability, don't really have the opportunity at that point in time, because they got to run across the street and dodge some traffic here and there, and probably by that time they can run back in, or because there's going to be another means of escape other than using lethal force. Now, I want you to think about another term is grave bodily injury. What's grave bodily injury? Well, almost anything. It's serious, it's important, it's weighty. Serious physical harm has a lot to do with lethal force. But when you're talking about great bodily injury, based upon a definition, serious, weighty, can cause death or serious bodily injury or harm, what in this room, look around, what can cause that? A pen, pocket knife, this? Someone in here may be armed, that? Box cutter, belt buckle, a frozen bag of squirrels, just about anything. I always say frozen bag of squirrels because there's actually a case out of San Francisco where neighbors were arguing over a fence line, and the one gentleman ran back in his house, brought out a frozen bag of squirrels, and beat his neighbor with them. But you know what? I always point this out because I believe it was in Nancy Pelosi's jurisdiction. She never came out with a law banning frozen squirrels. So look around. Anything can cause this. Now, what makes one person in here pull the trigger, if we're talking about firearms, and the next person not pull the trigger? It could be because it's subjective. We've all had different experiences in life. We have members of the military that have been trained. We might have martial arts experts in here, police officers, school teachers. We all have different experiences in life. I always say, raise your hand if you've ever been in a fight, ever in your life. And for those of you who have never been in a fight, how in the world are you going to know what it's like for that adrenaline to hit, what happens to your body? I encourage people to get slapped around a little bit, take some hand-to-hand combat course, to bear arms defense, just something like that to get your blood flowing so you have some kind of idea what's happening, especially if you're a concealed carry holder or if you're prepared to protect your life and the life of other people. You kind of want to have that. So I say, do something, whether it's karate, judo, or bare hands or empty hand combat course is good too. Just so you kind of know what it's like to get the adrenaline going, because when you're doing scenarios, case-by-case scenarios, they become pretty real. If you go to classes, I know John Bender's TDI, he has force-on-force with airsoft. You're in mask and you're dressed so you don't get hurt. But when you're doing a force-on-force and scenario training with airsoft, all of a sudden, maybe the first 30 seconds, it starts out as a game. A minute into it, it's not a game anymore. The adrenaline there, everything is going on, and you're in life and death battle. And that's just a great thing to do. So anytime you can do that, I encourage that. So the difference is subjective to everybody in this room. Why we use self-defense. Why I'll use self-defense and somebody else in here wouldn't. Completely reasonable. Again, that's for the reasonable person to take a look at. Me, subjectively, I was in fear of death or serious bodily injury or harm because of the ability, the opportunity, and I was in jeopardy. Now we talk about reasonableness. The reasonable person. I'm trying to stay behind this table. Usually I'd be running around everywhere else because we're streaming this. But if I was running across the room, running at somebody, said, I'm going to kill you, and pulled out a cell phone. As I was pulling out the cell phone, I took 2 to the chest. Did she shoot me improperly? Was it reasonable for doing what she did? I screamed, I'm going to kill you, went like this and started to come out, and she shot me? Was that reasonable? I subject, yeah. So it doesn't always matter what occurs or what the end game is. The thing is, a reasonable person, looking at all the facts, and the same facts and circumstances, would have done what she did. I'll go over a few more things and then I'll stand down for questions. Again, the important thing is the only reason why we use lethal force as good people is because we're in fear of death or serious bodily injury or harm. Be aware that in some states, that by statute, you can use lethal force really as almost becoming a police officer by witnessing violations of statute. The threshold question is always the same. You're in fear of death or serious bodily injury or harm. The only means of escape for you to safely escape is by use of lethal force. And that makes it pretty clear. I struggled for a long time. What do you say to kind of drive it home that this is the time to use it, when the only way you can save your life is by taking another life. The only means of escape is by doing that. And when you're in a duty retreat state, remember, you have to be able to safely retreat. And safely is a broad term. You know, if I had any hair on my head, I could say I can't have one hair on my head harm, or it's not safely. If you're in your house and it's snow on ground, before we had the castle doctrine, we had a duty to retreat from our home. If someone kicked their front door in and we could safely go out the back door, we had to. Well, if it's 32 degrees, snow on the ground, I'm in my socks, I don't have to. You know, I can't safely do that, so try to remember that. The threshold question will always remember the same. What is imminent? It's going to happen right now. It's impending, likely to happen or occur. Now, I used to do exercise. What is imminent or not imminent? Not if you meet me here tomorrow at 12 noon, I'm going to kill you. It's not imminent. Just I got good advice. Don't show up here at noon. As soon as I cross that room and get over to the back, I'm going to kill you. Well, yeah, that becomes imminent. You know, some of you in here have probably been taught about the Tua rule, 21 feet or less. You can use, I hate to put feet or distances on anything because none of us know how accurately can tell how far 21 feet is away. But remember, the average human being can travel 21 feet in about a second and a half. The average cop can draw his firearm in 1.5 seconds. And that's where that came from, and ties aren't good for any of us. So remember, eminence is going to be subjective, and it's going to be reasonable, and I kind of showed you across Northern Boulevard into the back of the room as being kind of the two opposites. Remember, the opportunity can occur at any time. If you're a concealed carry holder and you're going to Kroger across the street, I live in Westchester, or Liberty Township now, and when I first started carrying, I'd be kind of lazy about it. Well, I'm just going to Kroger. Well, how in the world do I know where the ability and the opportunity I'm going to be put in jeopardy? I can tell you it can happen anywhere. I've represented early in my legal career a lot of people that did some pretty terrible things, and you never would expect them to happen, where they happen, and when they happen. So we always have to be prepared because we never know when it's going to occur. Every 13 seconds in America, someone uses a firearm in self-defense. Every 13 seconds, folks. Now, that could be, hey, I have a gun, or I have a gun, or boom, I have a gun. But every 13 seconds estimated on everything that's going on, someone uses a firearm in self-defense. So it happens more than you think, and it can happen in different places that you think. Now, anybody have any questions with any of the law? Is it pretty clear? Lethal force in the law, when we can use lethal force is when we're in fear of death or serious bodily injury or harm. It's subjective. It's what do we think, not what does anybody else in this room think. Once we've shown that we reasonably use the firearm because we're in fear of death or serious bodily injury or harm, how do we prove that to that reasonable person in the jury? Well, that person had the ability, the opportunity, and I was in fear for my life. You should have a pretty good idea now when everybody in here can use lethal force. Now, that's a decision everybody has to make. I know some people that they don't care. They're going to live in their own little bubble. They won't take another human life, even if it means sacrificing their own. I don't think like that. I never did. I don't understand it. But just those people are out there. So I'm hopeful now, by the time, now that we're finished, is that we all have a good idea of legally when we can use lethal force. Really, there's no gray areas. When we're in fear of death or serious bodily injury or harm. I think we're going to pass the mic around. Is that correct?
First name, if you would.
Hal, saying that my fear of my death or injury, if someone has a knife to your throat and I'm there with a gun, what can I do?
We also have the right in the state of Ohio to use lethal force on behalf of a third party. So you can act on their behalf. And remember, you have to step on those people's shoes. What could that person do? Not what could you do, but would that person have the right to use lethal force? And I always say, make sure you see the whole thing come down or you see of everything. There's a situation in Columbus, Ohio. If you're an Ohio State Buckeye fan, the Buckeyes are generally right if they get beat by Michigan or if they beat Michigan. But usually every 5 or 6 years there's a riot. There's a riot at Ohio State, 2 plainclothes police officers witnessed a woman throwing canned goods, it was Bring Canned Goods Day, into the crowd and hitting people with them during this riot. 2 plainclothes police officers brought her down to the ground. In the process of handcuffing her, officer pulled back. A good Samaritan saw that, went up and attacked the police officer. Well, she was charged with felonious assault, and so was he, because he was improperly rendering her assistance to her. So you're going to end up being charged with the same thing if you improperly use self-defense on the third person's behalf. So I always say, make sure you love them and you're willing to go to jail for them. When people say, what if I walk into UDF and someone has a gun to the cash register person's head, what should I do? Hide behind the potato chips. Then make the decision, but I say that because the best gunfight you've ever been in is the one you're never in. And personally, I carry a firearm so I can get home and my wife and my kids can kiss me goodnight, and that's it. Yes?
My name is Tracy. Is there a different standard, reasonable standard for men versus women?
No, there's not a different standard. Remember, it's subjective to all of this. It could be a person in a wheelchair. It could be somebody in their 80s. It could be a 21-year-old kid. It could be a woman. It could be 4 people versus 1 person. So it's always the same. Remember, it's subjective. Now, maybe I subjectively wouldn't feel that I was in fear of death or serious bodily injury or harm, and you did. That's perfectly all right. So really the standard's always the same, but there's different ways to apply that standard, whether it's a group of force or whether it's a handicapped person, an elderly person, or something like that. But that's a very good question.
Yeah, I'm John. My question is, do you recommend that all honest citizens who are permitted to carry guns, can get CHLs, should carry, or do you think it's best to have fewer guns in society and fewer people carrying?
I believe that any able-bodied citizen who can safely and properly carry a firearm should be able to do that. I think over and over and over again, we've proved it. We've proved it in New York City. We've proved it over and over again in places that heavily restrict firearms, that more guns equals less crime every day of the week. Statistically speaking, uniform crime reports, in John Lott's books, that's the way it is. So the more of us that can carry, the better. Now, my daughter is 20 years old now. She can't carry. She can outshoot me, but she can't carry because she's not old enough. So I'm hoping that there's enough people in this room that are going to be there for her when the time comes. And as a criminal defense attorney, and Mr. Becker, that was a great question. As a criminal defense attorney, over and over and over again, I've learned that because the police, the bad guys don't know who's carrying and who's not carrying, they're thinking twice now. That's why crime goes down almost immediately. Even in Washington, D.C., when there was no concealed carry permits issued, as soon as Heller versus D.C. came out, violent crime plummeted. Yes.
My name's Lee. Scenario first, I guess. You're walking out of a store, returning to your car, and there's someone breaking into your car. Is there ever an advantage or a reason to brandish the weapon with no intention of using it to try and protect yourself? You just retreat, or how would you handle that? It's
kind of a loaded question. In certain states, you can protect property with lethal force. But I want you to understand something now. By brandishing firearms, say, stop, I have a gun and I'll shoot. That diffuses a lot of situations. But if somebody's breaking into your car, are you in fear of death or serious bodily injury or harm? No. And what happens as soon as you pull that firearm out? Somebody is in fear of death or serious bodily injury or harm, maybe the other person, so you have to be very careful. Now, I'm not saying don't brandish, but you brandish when you're in fear of death or serious bodily injury or harm. And that's one thing that's important to know. But there are some states that you can use lethal force, or you can brandish a firearm to protect your property. But that's a good question, because we all have scenarios in the back of our mind what we can do. But if they're breaking into the car, human life is more important than any piece of property in most states. So no, you wouldn't in that circumstance. But as soon as you did, who knows what they could come out with? Yeah, well, again, that's up to you. That's totally up to you whether you're going to try to intervene with somebody breaking into your car, or you're just going to call 911 and figure it's a piece of property. But that's totally up to you. Yes.
My name's Melinda. This may be sort of a silly question, but what do you think of the companies that advertise protection if you discharge your weapon?
Like second call defense, I started one.
Okay, okay.
So I'm the wrong person to ask.
Okay, so you do agree that it's a good idea to maybe have, well, whatever you call it,
Yeah.
insurance or whatever?
And what I did as a criminal defense attorney, year after year after year, representing people, number one, didn't have the money, who were good girls or good guys with a gun, didn't have $10,000 in their nightstand for bond, didn't have money for retainer, didn't have money for expert witnesses, didn't have $50,000 or $60,000 to take it through trial. And I said to myself, there has to be a better way. And I said that after about 5 or 6 hours at night going door to door with a young wife whose husband brandished, who legally brandished a firearm, but was charged in Fairfield for felonious assault, which was charged improperly. It wasn't a felonious assault. He properly brandished, but it was $100,000 bond. And he's 23 years old, she's 22 years old, and they have 3 kids under the age of 5. And so I got the phone call on a Friday evening, and it was somebody, I could hear somebody just crying hysterically. And being a defense attorney, I said, if you've been arrested, hand the phone to a police officer. And I asked what happened. He told me what he was charged with. And I knew that this kid would not be the same person Monday morning after spending Friday, Saturday, Sunday, and Sunday night in Butler County Jail. And I had to get him out. So I went and got his wife, and we went to every friend, every relative, every piggy bank until we got $10,000. 2 or 3 in the morning, I was able to bail him out. And that's when I said there's got to be a better way. And so make no mistake about it, if you use lethal force, no matter how properly or how righteous it was, it's probably going to go to the grand jury. There's going to be an investigation. It depends upon what jurisdiction you're in. How does a prosecutor think about lethal force? What are their views on firearms? There's a lot of different things that come into play. Unless you have the money to mount your own defense, then fine, do it. But I say, why waste your own money? People don't realize that, you know, that $10,000 we paid to bond this young individual out, that money's gone. That's what you're paying a bondsman to put $100,000 up. You're giving them 10. Well, the majority of that money is gone. So don't use your own money. I mean, it's as little as $9.95 a month to unlimited civil and $1 million worth of protection for $30 a month. And it's not about the money, and that's not when I did it. I just got sick and tired, and I wasn't even sick and tired of not getting paid, because I'm a terrible businessman. I'm a great attorney, but I always say I'm a terrible businessman, because when I see somebody that's really been wronged by the law, how can you turn that person down? And I couldn't. And finally, I said, there's got to be a better way, because there was too many law-abiding citizens that were being persecuted just because they were being charged improperly, or quite simply, the prosecutors didn't know the law. Laws are always changing in self-defense, and there was a time when it wasn't good to treat someone who used a firearm fairly.
Questions? Right back here.
My name's Jill, and Sean, earlier today, we had a discussion. What do you think the percentage of people who carry firearms now are? Like, say, a group out of 100.
I'll give you some statistics, and then we can talk through it. There's an estimated 15 million people in America right now that are licensed concealed carry holders. Now, that doesn't take into effect the 11 or 12 states now that have constitutional carry. And what constitutional carry says in West Virginia, for instance, if you're a citizen of West Virginia, you're over 21 years of age, and you're not under a firearms disability, meaning you can't own a gun or carry a gun, then you don't have to have a permit. It's your Second Amendment to the United States Constitution is your concealed carry permit. And there's 11 or 12 states like that now. So I guess it depends upon the groups that you're in, because a lot of times the people that I'm generally with, the vast majority of them are going to be, just because as a conservative, and somebody that grew up with conservative values and hunters, I have a large percentage of friends do. But if you're looking in the state of Ohio, we're looking at probably 600,000 permits in the state of Ohio, just Ohio permits, not even dealing with Florida, Utah, people that are traveling with reciprocity, meaning they don't have an Ohio permit, they have another state's permit. So out of 100, I don't know. I could think it could be as high as 25 or 30%. Yes.
My name is Carl, and I was going to ask you how much does it take to take a case to trial, but you just answered that, 50 to 60K?
That's on the low end.
Low end. Okay, my question is,
I don't mean to interrupt you, but I have a second call defense. We have a member in California, Santa Clarita County, just outside of LA. It's a nice suburb of LA. He had on film, his neighbor attacked him about a year ago, drug him out off his own front porch and beat him. And the police rolled up. Even with film, the police said, well, there's no witnesses, it's mutual comment. I just realized you're here. How are you? And I called 4 attorneys, 4 of the top attorneys. Every attorney wanted $100,000, and they wanted it all right now. And it was non-refundable, meaning if a week later, that's not ethical in Ohio. You can't do that. But in California, you can take $100,000 up front, and if it's over within a week, the attorney keeps $100,000. So that's what that was, and that was just his attorney's fees. Now there's expert witnesses, so sometimes it can end up being quite a bit of money. But if you have an attorney involved immediately, generally speaking, I'm comfortable with $50,000 being enough to mount a defense. If it's a true self-defense shooting, or even a self-defense shooting that may be in a gray area, it's hard to think that prosecutors in today's day and age aren't going to take a look at things with the right criminal defense attorney up front, speaking to people. And again, that's why it's important to have somebody from where the shooting took place representing you. But go ahead with your question.
okay, have you found that a person's homeowner's insurance policy or an umbrella policy that they have for, say, $1 million would ever pay for an attorney's?
You know, I used to think my multi-million-dollar insurance policy would as an attorney. One of the reasons why I started second call defense too is I found out that it's against the law, and there isn't a liability policy, there isn't an insurance policy or a home or an umbrella policy that can cover you. Homeowners policy do not cover intentional acts. And when you shoot somebody in self-defense, make no mistake about it, you intentionally shot them. Also, there's another provision of federal law, federal insurance law, that quite plainly states that an insurance company cannot compensate you while you're a defendant in a criminal proceeding. Now, if you're acquitted, then they can reimburse you, but if we had the money to be reimbursed, we wouldn't really care. Those are good questions, and insurance companies can't cover you. Second call defense, that's why Carry Guard and a few other ones pay like a small percentage, or it's all reimbursement. Well, I started a foundation, and I use Frost, Brown & Todd as my law firm, and with a foundation, I have a foundation funded, so if you're a member of second call defense and you use your firearm or self-defense, the foundation would write you a check. And then after the end, win, lose, or draw, the insurance policy reimburses the foundation. So you get all your money up front, and since the foundation is an educational foundation, it's not considered insurance, so they can pay up front. Remember, insurance companies cannot pay up front. That's a good question. I mean, I thought my homeowner's policy, well, I had a multi-million-dollar umbrella policy. Yes.
My name's Valerie. My cousin tells me if I have to shoot someone in my home and they get outside, that I should drag them back in.
You know what?
Is that true?
My dad used to say that all the time when I was growing up. No, that'd be tampering with evidence, moving bodies around and messing with the crime scene. I can tell you that the standards is if you're in fear of death or serious bodily injury or harm, you don't need anything else. There's been cases litigated at the Ohio Supreme Court in almost every state that people have been shot through the door. They're kicking the door, they're trying to get in, you're screaming stop, that's your home, that's your castle, and you use self-defense before they even enter your home at the threshold of the door, because the courts took the common sense approach. We don't have to wait to get stabbed a little bit, beaten a little bit before we can use self-defense. We can do it to stop it. And so, you know, my dad used to tell, I used to hear him say that too, if you shoot them, drag them back in. Now, you don't want to do that. You don't have to. Yes?
Hypothetical, if someone breaks in and you are in fear of your life, would it make a difference whether you shot that person or hit them with a baseball bat and they died as a result?
Now, lethal force is lethal force no matter what you use. It's still, I mean, you can't kill somebody a little bit. So it doesn't matter if you use a baseball bat or a firearm or a knife. And really, death is death, and I don't like it when someone gets a higher crime for using a firearm than they would with a knife or something else like that. But no, it doesn't matter what it is.
More questions, right back here.
Hi, I'm Rhonda. I have the educational question.
Okay.
I work in a high-profile facility, and there have been threats across the United States. So, if I have a gun, I know I've been told I can't carry it into the school, but I keep it in my car. So, if I was in a situation where I could get to my car, which I park very close to the building, could I use my gun to protect the kids of my classroom and the whole school?
Certainly you could do it, but you'd be doing it illegally. You know, and I'm going to give you, Mr. Becker, could you come up here? One of our biggest proponents of gun rights and gun laws of the state of Ohio is John Becker. And he has some legislation, and we just spoke about a question similar years. Now, we have faster, and we've made some great strides with carrying firearms. It used to be you can only carry a firearm within a school safety zone if you were immediately in the process of picking up or dropping off your kids, period. Couldn't get out of the car, was against the law to leave a gun locked in the car in a school safety zone, and you couldn't be dropping off homework. It had to be immediately picking up and dropping off the kid. We've expanded that to any legitimate school purpose, but still, now the school board can pass a resolution to allow concealed carry within a school safety zone and give you specific written permission, so it legally can be done. So yes, it can be done. If you do it in your scenario, you're still going to be guilty of a crime, but if you just saved 33 kids from being shot, who's going to prosecute? And if they do, call me. Mr. Becker. I don't mean to put you on the spot, but it's important that we listen to our legislatures and have the opportunity for input.
Yeah, it was as simple as before. It was Senate Bill 99. It was just in the last General Assembly. So in the past year, we changed this law. But it had been that if you're driving down the highway on a Sunday afternoon, and then you get the blue lights behind you, you're getting stopped for speeding. So you go stop your car and you pull into a school parking lot, and then you tell the officer, I have to tell you I have a CHL and I have a gun. Well, you're following the law by telling me you have a gun. But now you just committed a felony because now you're in a school safety zone carrying a gun. That was the law up until about a year ago. We just fixed that. I'm working on a bill right now. I just had one that passed the House that decriminalizes some of these gun-free zones. It reduces it from a felony to a misdemeanor. So where this new bill I'm working on now, where it's going to affect teachers, it's for all of these so-called gun-free zones that are public property. So schools would be included. So it says if you have a concealed carry permit, and if the place doesn't have courthouse-style security, which schools do not, then you can carry a gun. And if you're an employee and carrying a gun, that you can't be disciplined or fired for that. So that would give you options and would be able to help with any situation that would occur inside the school.
Thanks.
John's a big friend of EmpowerU. Let's give him a round of applause just for joining us. Thank you, John. Appreciate it. Let's have some more questions.
My name's Jason. What are our rights when you see private businesses that have signs that say, basically you're not allowed to bring your gun in here? What are my legal rights with that?
Your legal rights are, they have a civil trespass action for that. And the way that it's drafted is that you have to knowingly violate that sign. So you have to see the sign and say, I don't care the sign is there, and go in. If you go in and you don't see the sign, it has to be conspicuously posted, meaning you don't have to look for the sign, it's right there. If anybody ever goes to B-Dubs, there's one in Bridgewater Falls that I noticed, and there's several other ones. They have very dark tinted glass. I probably shouldn't be saying this because then they'll get on to me. But they have a dark sign that says no guns. The only way I saw it, I was going there for 3 years, is I dropped my wallet and picked it up, and I saw it at the bottom of the door. Well, it's not conspicuously posted, so they really can't enforce it. But remember, it has to be conspicuously posted, and you have to knowingly violate that. Now, based on that, to my knowledge, there's never been anybody successfully prosecuted in the state of Ohio, because what's the problem with proving I knowingly did something? Unless I say I did it, I meant to do it, and I'm going to do it again, you can't. The government hasn't found a way to get in my head yet and know if I knowingly did anything. They don't know my state of mind. So, Jason, that's a good question. There's civil trespass, and you have to prove that they knowingly violated it. Now, as soon as you see them with a gun, and if it's concealed, I don't know how you can, and you ask them to leave, they have to leave. And Mr. Becker has also had legislation dealing with that, too, and that's part of the decriminalization of no gun zones and posted zones also. Pardon? No, but I meant posted, not post office, but posted sign. Yeah.
Fred, if I have to go into a school, I've taken my gun and locked it in the car to go into the school, but I'm parked in the school parking lot. Am I illegal?
Yeah. Even under the new law, I'm not sure you can only take that and leave and get out. Maybe it's changed somewhat. Yeah, and CHL locked in your car, so you can do that. But now, what if I just decide I know I'm going to a football game that night? And what House bill was that you changed that? That was Senate Bill 199. That was what, last year, right? Yeah. So yeah, you're legal to do that now, but in the past that you weren't, if you have a concealed carry permit.
Here's a question right here.
Yes.
You're using the term locked in the car. I have a Suburban, Chevy Suburban. I have a glove box. I have a console in the middle, neither of which have any key operation. They can both be, so is locked in the car with the car doors locked, or can I never carry concealed or leave a concealed weapon in my car because I don't have a glove box or a console to lock it in?
No, just locked in the car. Now it'll be different if you're thinking about the interstate transportation of firearms from state to state, where the gun has to be locked if you don't have a concealed carry permit for that state. That the gun has to be locked separately in a locked container, with the ammunition kept separate. So if you have no way of locking, it has to be in a separate lock case. But locked doors is enough. Yes.
Hi, I'm Rick. I've heard that there's a federal law on federal property, for example, post office. If you don't have it locked, just drive in the post office, drop off mail. Now, is that a violation because you're on federal property?
Yep.
Still that way.
Yeah, it's kind of a dirty trick because you can't lock it in the car on federal property and you can't go inside on federal property. And boy, you don't want to mention gun in a post office. I had a stack of mail. The world knows me as a criminal defense attorney who deals in firearms rights and issues. I'm also on the board of directors of the National Rifle Association, so my life deals with firearms. Well, I was in the post office with a couple of gentlemen that went to my Friends of the NRA banquet, and they said, "Hey, did you see all of those guns?" And just they made a statement like that, and a woman was coming out from behind the counter and says, "Who has guns?" No one has guns. But yeah, they're serious about it, and that's a problem with federal law that comes up. The parking lot is federal property, and so is the building. So,
Other questions for our speaker? Right here.
Hi, I'm Mike. It may have been in Buckeye Firearms. I just read something about changing the law that if someone accidentally or someone forgets to tell an officer that pulls them over first thing that they have a carry permit and a gun on them.
I testified for that. Was that your committee? I testified in front of his committee last year dealing with that. I'm going to have him address it after I tell you why I was so passionate about this. The vast majority of cases dealing with concealed carry holders that I undertake and represent right now is for people who don't promptly inform. The law in the state of Ohio is if you have a significant contact with the police, whether you're pulled over speeding or they're talking to you on the street about something, more than just a casual conversation, then you have to promptly inform. The problem is promptly is a moving target. What is promptly to you isn't promptly to me. Now, I helped draft part of the section in the Attorney General's handbook, hands on the steering wheel, window down. When the police officer comes up, my name is Sean Maloney, I have a concealed carry permit, and I have it with me immediately, because then I know there's no question. But there's many other people that, they don't get pulled over all the time. Do you know how fast you were going? We're going in such a hurry, it's dangerous. You're approaching a school. You got to pay attention to that. Let me see your driver's license and registration. The person hasn't had the opportunity to say a word. Hands them their driver's license, registration, and concealed carry permit, and they're arrested for not promptly informing. And same person, same circumstances, the police officer isn't going to arrest them. So that was my problem, is that promptly was really vague and overbroad. Texas does it. Once they ask for your driver's license or your ID, then it's your responsibility to inform the officer. 36 states, I believe, 32 or 36 states was research I did, require that you only tell the police, you only have to have a duty to inform a police officer if they ask you. To me, which makes sense. I mean, Buckeye sheriffs want to argue about the fact, safety of, and if I'm a police officer, I'm not going to rely on someone to tell me. I'm going to ask, not that I think a bad guy's going to tell me the truth, but at least I'm going to do that.
Yeah, I'm on the committee who heard that bill. That was sponsored by Representative Scott Wiggum. The story that he told was that there was a situation, I'm not sure if these are his constituents or where this happened, but I think there was an accident or something.
That's one of mine. One of my cases.
It was one of your cases.
Yeah.
Okay, well, you're probably a better person to tell it. Oh, go ahead.
I got a phone call from a gentleman who was a concealed carry holder, and he was an offender bender. And it must be most of the sheriff's department that night didn't have much to do. 4 different cars pulled up in the course of half hour, 45 minutes. Well, he had informed 3 out of the 4 police officers. He didn't know number 4 was even there because number 2 looked like number 4, and so he didn't tell number 4. Well, number 4 cited him for failure to promptly inform. He just told 3 police officers I'm a concealed carry holder, and then I told Mr. Wiggum that, and that was just one of the things, and you can go on from there and talk about the problems that we're having with this and why we need your help.
Yeah, there was we saw a video where I've heard it called mad cop disease, where somebody had a gun and didn't promptly tell the officer, and it promptly was in whatever definition the officer had in mind at the time. So this is what we want to think of as a rare abuse of something crazy that happens, and I do accept that it's something like that is rare. I'll tell you, just kind of jump to the end here. The compromise legislation that passed the committee was that when the officer, so you get pulled over, when the officer asks for your identification, at that point, if you have a firearm with you, at that point, then you must tell the officer that you are armed. If you do not, it reduces the penalty. It reduced, I think it was a felony.
Right, it was a felony.
And now it's reduced down to an M4. That's a 4th degree misdemeanor, and with a fixed $25 fine. But there's also court costs on top of that. And I was just researching that here in Claremont County.
$150 court costs.
$75 in Claremont County.
So
it
it's
depends
not
where
cheap.
you are. So it's $100 kind of minimum if you're in violation.
Mm-hmm. And that's that's common sense. I don't think requiring the bad person is never going to follow the line anyhow, and that's what we always have to try to remember. But we're trying to clean these up. The self-defense law and concealed carry laws are kind of a mess. I wish Mr. Becker could do, which I know he wants to do, take them, tear them up, and make them simple.
My name is Mary. When I travel across the United States from west to east, and I carry a 1927 double-barrel shotgun that I was told is inoperable because the wood is cracked, so there's no ammunition. Am I going to be okay in every state with the exception of Illinois? With
no ammunition, and there is a law that allows safe passage for you throughout the United States. The firearm has to be inaccessible in a lock container in a trunk if you have a trunk, or in a lock container in the back of a minivan if that's the way it is. Any ammunition has to be kept separate, and legally you can travel. And if you have no ammunition, then keeping that firearm locked up is going to be you're going to be allowed to travel safely with that. Yep. What's that? Even New York, but the problem is I got to caution you, I can't control who's going to follow law and who's not going to follow law.
My name is Pete, and I have a follow-up question to the post office.
Mm-hmm.
2 places on the west side of Cincinnati. There are post offices. One of them is actually in a hardware store. The other one is actually in a strip mall. Where does the parking lot stop and start? And if you go into the hardware store where they have a post office sitting off to the corner in a separate area, where does this, you're going to jail for life if you carry your weapon in there, if you just ran in to get a detachment for your garden hose?
There's the Ace Hardware on Liberty Fairfield Road across from the Kroger, now right across from One Stop Tool Rental with a little post office in the back. That's a private business that happens to have a post office in the back. The government doesn't own that parking lot, doesn't own that building. It's not a government building, in my view, until you get back to the area that's the post office. So, and really, the only way to, I guess if you went up and tried to transact business, maybe that would be considered the part that they lease or they rent, it would be considered the government property. But in that situation, again, it's not government owned. It's privately owned building, privately owned parking lot, and they allow concealed carry. And in my view, not until you're transacting business with the post office are you in violation. It gets to be a government building. It's a federal building is the problem in the federal property carrying a firearm is what it all comes down to. It's just not because it's a post office.
Oh, my name is Dan. My question is, when an officer pulls you over, the technology we have today, does he not take a moment to look at your plate to do a read? And at that point, he knows whether you're a concealed carrier or not. So doesn't that play into it? Thank you.
Kind of. And this is how it kind of does. The penalty, it's a bifurcated penalty. There's two different penalties. If they run your plate and they know you're a concealed carry holder and you don't properly inform, and they don't run your plate and you don't properly inform. If they run your license plate and they find out that the car is registered to you, who is also a concealed carry holder, and you fail to promptly inform, well then it's a misdemeanor. You don't lose your concealed carry permit, there's a small fine, and you go on your merry way. But if they didn't run your license plate and had no idea whether you're a concealed carry holder or not, and then you didn't promptly inform and they found out later, then it's an elevated crime, mandatory 6-month suspension. You're going to go to court, and every time I went to court, the first thing I want to do is seize your firearm. So in the state of Ohio, there's two different penalties, if they know or if they don't know. Now, are you going to address that subsequently then with your change in the law, whether they know or they don't know? I guess it probably that would just go away.
No, there's still a knowingly standard is built into all of these gun laws. And the only exception is in a bar.
Right.
So this new bill that I'm working on, it applies knowingly to the bar at all, in addition. So assuming the bar is not posted, that there's no gun, no sign says no guns allowed, so we're talking private property. If it's not posted, under current law, you can go in, if you have a concealed carry permit, you can actually go in open or concealed. It's a little quirk in the law most people don't know about. However, if it is posted and you go into the bar under current law, whether you knew you had the gun or not, you could get arrested. And it's I believe it's is that an M4?
Yeah, that's an M4 also.
Okay. But in this new bill, I'm going to change that to make the standards consistent throughout the Ohio Revised Code, where you have to knowingly carry the gun. And why that's important is because a lot of times, if you got a gun in your purse, or if you walk around with a gun all the time on a regular basis, it's easy to forget you have it. And so that's the reason that standard is in place.
People say, how could you get caught accidentally bringing a firearm, through the airport? Well, I travel all the time, and again today, even though I didn't have a gun in San Diego, there's that moment of panic when I'm going through the X-ray machine, because I always carry, and I think, oh my God, is it there? But if you do it all the time, it's like a wallet. You notice when it's not there, not when it's there. So, and that's why common sense is needed in a lot of these laws.
Two quick questions, and then that's all the time we have.
Okay, an addendum to this gentleman's question about being stopped. I was stopped in Fairfield, and I knew that the cop is going to see my license plate and say, oh, he's a concealed carry. So I automatically stuck both hands out the window. Well, the cop thought this was the funniest thing in the world, and said, I know you're a concealed carry, and I'm not worried about you.
Right.
If I get in a gunfight, I want you helping me anyway. He said, just slow down, and that's it. Now, what I'm wondering is, question, is there an attitude in various jurisdictions about we don't like concealed carry people, or we do, or?
In my view, and in most jurisdictions, police officers are of the feeling that you're the good guy with the gun. More and more, you'll get sheriffs saying, you know what, this badge represents everybody behind us, and you need to be armed. I mean, Rick Jones over and over and over again. Sheriff Jones in Butler County says, you better get a firearm. We can't be there. When you're looking at 52-minute response time to 911 calls, some parts of the country, you can't rely on 911 because they're not going to get there no matter what the incident is. I think, generally speaking, maybe there was some nervousness at the beginning of it, but concealed carry has been in Pennsylvania as long as I've been alive, in Ohio for 11 years now. It's everywhere in the United States. The police officers see, because of us, that we're the safest, most law-abiding segment of society, and they're not panicked. Now, you'll get people from Buckeye Sheriff's Association coming up and say, blood is in the streets and everything is Dodge City, or whoever it is. But that just doesn't happen. Just look at what happens in Indiana, Kentucky, West Virginia, Pennsylvania, and Michigan. Why are we going to be any different? And we're not. So, but I think the general attitude is you're the good guy with a gun or the good girl with a gun, and they're happy to have you.
Last question.
I'm Betty. If you're a concealed carry holder and you let someone else drive your car, you're not with them, they get pulled over, and the policeman knows when he approaches the car that that person that owns the car is a concealed carry holder, but the person driving doesn't say anything. What happens to that person?
You don't have to say anything. If you're a concealed carry holder, doesn't matter whose car you're in, if you have the firearm, if you're a passenger in the car, you have to promptly inform the police officer. If you do not have your firearm, you're under no duty to say anything. So that person is safe in your car, whether it's your kids or a relative or a friend, even though the car is registered to that, and it's not you. And if you don't have a firearm, then you don't have to disclose or tell them anything, and that's kind of why that's in the law. But keep in mind, if you're in an automobile, a passenger in the back seat, you still have a duty to promptly inform. That was a good question.
Let's thank our incredible guest tonight, Sean Maloney. Thank you very much, Sean. And John Becker also. And so I had 3 incredible research assistants get us this program together: Betty Overstreet, Nita Thomas, and my executive assistant, Jill Google. Let's thank them. If you have anything to do with computers in your life, in your business, whatever, do not miss our friend Dave Hatter Thursday night when he will discuss everything about cybersecurity. Thank you for joining us tonight. Everybody have a great night.
Folks, there's a few more of these books back there. They're $10. I didn't write it. I just read it, and she's a friend of mine. What a great book. In fact, you need one because I give you permission to go to Columbus and do absolutely nothing. We have enough laws, we have enough regulations, and that's what that's all about. It just gets us thinking about what we want our government to do. Yep.
I got 3 cars, but they're owned by my business.